I begin, the defense would like to ask for a time check.
The defense currently has 6 minutes and 19 seconds left.
Thank you. Good evening, Your Honor. Once again, my name is Liam Hamilton on behalf of our client, Logan Gold. Today, the prosecution has brought forward the accusation that Logan Gold kidnapped Taylor Alexander on November 11th. But as we stand here today, it is clear that the prosecution is missing something fundamental, dare I say elemental, to their case. And that something is gold. Now, I'm not just talking about gold, the man. I'm talking about gold in the scientific and the legal sense. An element in a court of law is something that we use to prove a person's guilt. And according to Calcrum 1215, the elements of kidnapping are clear. For you to find Logan Gold guilty of kidnapping Taylor Alexander, the people must first prove beyond a reasonable doubt that Logan Gold is guilty of taking, holding, or detaining Taylor Alexander using force or fear. Using that force or fear, Logan Gold moved Taylor Alexander a substantial distance, and 3, Taylor Alexander did not consent to the movement. For you to find Logan Gold guilty of any of these elements, the people must first prove the first, and they cannot. The physical evidence that they have brought forward today does not conclusively prove that Logan Gold is the only person capable of kidnapping Taylor Alexander. The dockline rope is widely available to anyone in this town. The cough syrup is widely available to anyone in this town. And the catchphrase that has been used through this trial can be heard by anyone in this town. The evidence does not line up. The tire tracks found at 1335 Lakeside Drive are a common tire, total tire 350, and both experts claim that there is a difference in the tire tread depth, a very substantial amount of 1/32 of an inch. But in tires, this is a lot. And the pebble that the prosecution points out in the tire of Logan Gold is merely insignificant, as it left one impression in the dirt. As well, Logan Gold went across an unpaved gravelly fire road in Emerald Bend, an unpaved gravelly town. As well, Detective Kim did not assess Taylor Alexander's tires and did not follow through investigating all aspects of this case. The physical evidence does not conclusively prove that Logan Gold kidnapped Taylor Alexander. Now, when the physical evidence does not add up, you must turn to circumstantial evidence. And when faced with circumstantial evidence, if you can draw 2 or more reasonable conclusions drawn from the circumstantial evidence, one which points to guilt and one which points to innocence, you must accept the one that points to innocence. Now, here are the defense's 2 reasonable conclusions drawn from today's circumstantial evidence. The first, Taylor Alexander faked her own kidnapping. The evidence that we've brought forward is this. C.J. Costley informed Taylor Alexander about the West Death case, a case where a man faked his own kidnapping. Taylor Alexander claims to have been thrown in the trunk of Logan Gold's car, but there was oxalic acid found on the fibers of Logan Gold's trunk, and there were no traces of oxalic acid on Miss Alexander on the day of the kidnapping. Miss Alexander claims to have been dragged down a muddy hill, and the detective found mud on her clothes, but no mud on the pillowcase. As you heard from today's trial, the prosecution has tried to bring forward the accusation that Logan Gold kidnapped Taylor Alexander, but it is simply unreasonable. They ask you to believe that my client left not 1, not 2, but 3 distinct calling cards at the scene of the crime. The pillowcase with the gold standard in, his name and his workplace. The words written in Sharpie on the pillowcase, Duray for Emerald Bend, his wife's name. And 3, his catchphrase, everything comes back around. What reasonable criminal leaves 3 distinct calling cards that directly link them to a crime? It's unreasonable, unless it's a setup, or the wet bandits from Home Alone. The prosecution has brought forward the second, or the defense has brought forward the second reasonable conclusion. This is a setup. Somebody else kidnapped Taylor Alexander, unbeknownst to us, and has framed it on Logan Gold. The dockline rope, the common tire tracks, the cough syrup, the catchphrase, the pillowcase that was robbed from Gold Standard Inn. All of these are accessible to anyone in the town. Anyone could have done it. There is too much reasonable doubt to only point to Logan Gold. The detective only looked at Logan Gold throughout this entire trial. They did not investigate any other witness's property. They executed one search warrant and questioned Taylor Alexander one time. You heard from the prosecution's own witness, Dr. Ray Forrest, that her testimony, Taylor Alexander's testimony, could only be credible after a substantial amount of time. Did Detective Kim ever follow up with Taylor Alexander? No, he did not. By Dr. Forrest's own assertions and expert opinions, Taylor Alexander's recollection of the events of that morning are not credible. They cannot be trusted to put a man behind bars. In this courtroom, the law is our periodic table, and the elements of a crime are what we must measure. The prosecution has not met the elements of Calcrum 1215. They have not reached the burden of proof. They have not proven that Logan Gold is guilty of kidnapping Taylor Alexander. We ask you to return a verdict of not guilty, because Gold, the element, is simply not there, and Gold, the man, is simply not guilty. Thank you.
Any rebuttal?
Yes, Your Honor. Beyond a reasonable doubt, all aspects of kidnapping have been present by the prosecution. As the defense stated, the costume, the voting supplies, the dog line rope have been available to all. That does not exclude Gold. Why would Gold not have a motive? All physical evidence has been pointed to Gold. The evidence all points to guilty. The strong accusations of Taylor Alexander faking his own kidnapping for what? To lose the election at the end of the day.
30 seconds.
There would be no reason why the pillowcase that the defense had mentioned to be filled with mud. It is simply not reasonable in this case. Taylor Alexander was asked after they had gained clarity too, not while they were under the cough syrup alleged, but after they had gained clarity. That would be all. Thank you, Your Honor.
All right, defense, any rebuttal?
Yes, Your Honor. The people believe that Logan Gold made a power grab at political office, but Taylor Alexander had twice as much motive. She was unemployed and relied on her 2 vacation rental homes for a source of income, and was preying on the downfall of the Gold Standard Inn in the meantime. Now, the prosecution believes that anybody could have kidnapped Taylor Alexander, mainly Logan Gold, because the tire tracks were found at the scene of the crime. The prosecution has brought forward no total concrete evidence that Logan Gold's tires were ever at 1335 Lakeside Drive that day. They do not have the physical evidence that conclusively points to Logan Gold alone. There is too much reasonable doubt, and you cannot find Logan Gold guilty on reasonable doubt. The people have not met the burden of proof. They have not met the elements of Calcrum 1215, and therefore, Your Honor, we ask you to return a verdict of not guilty. Thank you.
Before I issue my verdict, students may confer with their attorney and teacher coaches regarding any trial irregularities. You can take about 30 seconds to do that. Why don't you do that now? And I'm sure. All right, with the prosecution team, like to know any trial irregularities.
Not at this time, Your Honor.
Defense team, any trial irregularities you want to know?
Briefly, Your Honor. During testimony of trial, witness Taylor Alexander refers to the voice that she heard as specifically Logan Gold's, but as stated on page 32, line 40, my captor was intentionally distorting their voice. I could not recognize the voice or even the gender of the speaker to the effect. Additionally, according to rules found in the rulebook section 3.2, clause M, in keeping with the educational philosophy and objectives of the mock trial program, teams should concentrate on realistic presenting of the trial with the witnesses wearing appropriate courtroom attire and using their normal speaking voices. Portrayals of portrayals of such are inappropriate and not allowed.
And are you referring to any witness in particular?
Yes, Your Honor. The defense points to Detective Taylor, Deputy Kim.
All right, so the court also noted both of those items that you cited. I agree. Well, do you have a response first?
The prosecution would like to ask what line you're referring to for Taylor Alexander.
On page 32, line 40, 41, and 42. It was extremely gravelly and almost whispered, like my captor was intentionally distorting their voice. I could not recognize the voice or even the gender of the speaker.
Yes, I recall that they gained clarity after, and they stated that they had not known his voice at the time of the kidnapping.
All right, I believe that the defense team is correct about that, and I know that that mental involved in that testimony was occurring. That according to the statement of facts in the materials, the alleged victim couldn't identify with certainty that it was the defendant's voice.
During the questioning, we asked if it was after they gave clarity, and then after they proceeded to state that looking back, it reminded them of Logan Gold.
So is there something you can cite in the statement of facts that indicates that at some point later, the alleged victim did identify the voice as being that of Mr. Gold?
Page 33, 7 through 13.
Page 33. And what was the line?
It's 8 through 13. It's stating how they heard Logan Gold mention that. And it was a contract with them.
Your Honor, may I be heard?
Yes, ma'am.
The statements that the counsel is referring to on lines 8 through 13 refer to the statement made by the captor, everything comes back around, and that is familiar to Taylor Alexander. During trial, Taylor Alexander testified that she heard Logan Gold's voice, not the statement that she made, but Logan Gold's voice.
I agree with the defense team on this one. What the witness stated in the statement of facts, or the witness statement, was that it was a catchphrase they recognized as being a catchphrase used by Logan Gold, but not that they specifically recognized Mr. Gold's voice. So I think the issue is that the defense team is valid here. And then with regard to the second item, the witness portraying Deputy Kim unquestionably spoke with an accent and affect to their voice. What I don't know is whether that is how the team member actually speaks in real life. But I did detect that, sort of an exaggerated southern drawl and certain manners of speech. So if indeed that is not how that witness speaks when they're not portraying that witness, I would concur with the defense team on that issue.
If I may, Your Honor, I believe that the voice was with clarity, and I believe the accent didn't affect how the information was portrayed to the court.
All right, I understand the counter argument, but I decide with the defense on this one.
Yes, Your Honor.
Thank you, Your Honor.
All right, so the court is going to announce its verdict. I think there is a lot of circumstantial evidence in this case. There's really no direct evidence. Direct evidence would be something like a witness who actually saw the defendant kidnap the victim, or video of that happening, for instance. So, as was raised by the defense team in the opposing argument, if you can draw two or more reasonable conclusions from circumstantial evidence, and one of those reasonable conclusions points to innocence and the other to guilt, the court must accept the conclusion that points to innocence. And of course, the defense doesn't have to prove that the victim kidnapped himself. That all they have to do is raise reasonable doubt, and the court believes that reasonable doubt was raised by the defense team. So the court does find the defendant not guilty. So now, the teams have 2 minutes to decide which student from the opposing team should receive the MVP certificate And of course, the scores, if you haven't done this before, bear in mind the court's verdict has no relevance to your score.